So now we shall discuss what all are the limitations of this collegium system. What are the limitations of this collegium system? So first is lack of transparency. So there is a lack of transparency in this collegium system. How? So the meetings of collegium, they are closed door meetings. There is no particular secretariat of this collegium. There is no secretariat of this collegium. So the meetings are closed door meetings. There is, and the official minutes of meetings, the information about the facts given in the meetings, what was discussed in the meetings, what were the arguments posed by different judges in those meetings, they are not completely brought in public domain. So basically, since there is no secretariat, no official minutes of the meeting are released. So there is lack of transparency. Moreover, as we know, the Constitution of India provides certain basic qualifications, qualifications for appointment of judges to Supreme Court and High Court, but it remains silent on the elaborated, the detailed qualifications that should be needed. So basically, there is a gray area. So there is no particular criteria, no specific criteria that should be followed by the collegium while deliberating on the names to be recommended and while making recommendation about the names. So there is no specific criteria apart from the basic qualifications given in the Constitution of India, which again creates the transparency issues. So since there is lack of transparency, so what happens? It gives a lot of scope for nepotism as well as favoritism. So in past as well, there are allegations on judiciary about the nepotism and favoritism. So apart from this lack of transparency, it is also said to be unconstitutional. Why this collegium system is said to be unconstitutional? Since there is no mention of this collegium in the Constitution of India. Only term given is consultation, and it is said that the Supreme Court of India has manipulated the meaning of this term consultation to bring the collegium system. So it is basically not mentioned in the Constitution of India, so it is unconstitutional. Moreover, they said that it is undemocratic. The collegium system is undemocratic. How it is undemocratic? Since judges are not directly elected by the people of India, there is no direct election of judges by the people of India. Moreover, they are not accountable to anyone directly. They are not accountable to the people of India directly. Although India is a representative democracy, and there is a provision for impeachment of judges in India, but as we know that this impeachment of judges is so tough that so far no judge, not even a single judge of Supreme Court or High Court has been impeached. That is why there is lack of accountability and it is said to be undemocratic. Moreover, it is also said that this collegium system leads to inadequate representation of certain sections of the society. For example, there are very few women judges in higher judiciary. To deal with all these limitations of the collegium system, the Parliament of India came up with National Judicial Appointment Commission Act as well as 99th Amendment Act. So the Parliament introduced this 99th Amendment plus this National Judicial Appointment Commission Act in 2014. So what were the provisions of this NJAC Act? So this act basically provided that there shall be a commission which shall recommend the president on the appointment of judges to higher judiciary. So who shall be the members of, what shall be the composition of this particular commission, who all shall be the members. So the Chief Justice of India was to be the chairperson of this commission. Furthermore, two senior-most judges of Supreme Court, they were to be the members of this commission. Moreover, the Law Minister of India was also to be the member of this commission. Apart from these four members, there were to be two eminent persons from civil society who shall be nominated on the advice of a committee consisting of Chief Justice of India, Prime Minister of India, and the leader of opposition in Lok Sabha. So apart from these four members, there shall be two more members from the civil society who shall be nominated by Chief Justice of India, Prime Minister of India, and leader of opposition in Lok Sabha. But the Supreme Court of India, in the fourth judge's case, struck down this 99th Amendment Act as well as this NJAC Act. So they struck down this NJAC Act in the fourth judge's case.